variety of topics and features guests from business, law, politics, government, education, and some of the most insightful entrepreneurs. It's a refreshing, common sense approach to some of the most important discussion points today. Now, here is your host, Kreis Chatman.
Hello, everyone. Thank you for joining me today on Getting Common. I am Professor Kreis Chatman, and by day, I am an associate professor at Washington and Lee University School of Law, where I teach all things business and commercial law and write on business, legal ethics, corporate governance, and personhood rights. The topic of today's episode is the fight for the right to choose, and it is a very timely topic because as we record right now, the Supreme Court is hearing oral arguments in Dobbs v. Jackson Women's Health, a case out of Mississippi that seeks to implement a ban on abortion at 15 weeks, and that also seeks to overturn Roe v. Wade and Casey, the two cases that give us the right to choose. So in addition to that, on September 1st, Texas passed an abortion ban at 6 weeks that, because of the procedural requirements, has been allowed to stand. So for the last 3 months, Texas has had a de facto ban on abortion that has been mired in the courts and impossible to unravel. So to kick off our discussion today, I have assembled some great guests, and I'll let them each introduce themselves, starting with Professor Anthony Kreis.
Hey, so I'm Anthony Kreis. I am an assistant professor of law at Georgia State University College of Law and also a proud alumni of Washington Lee University School of Law. But I teach constitutional law, focus on civil rights, and I do a lot of work as well as a political scientist with American political development and how law and society and courts interact. So good to be here, and I'm very happy to be part of the inaugural podcast. So congratulations on that.
Thank you. Our next guest is Galina Varchena of NARAL Pro-Choice Virginia.
Hi, I'm the policy director for NARAL Pro-Choice Virginia, and also an attorney, and I've been with the organization since 2017, and during which time we've done some really good things in Virginia, but now post this election, we're going to have to do a lot of defense. So I'm glad to be here to talk about this important issue, and I just came back from the protest in front of the Supreme Court. It's a wild, wild time.
Yes. Well, I always feel, whenever there's Supreme Court Day, I feel very anxious, and then I feel anxious until June about it. And so I kind of wish they would decide a little sooner, but here we are. All right, and last but not least, my dear friend Richard Jones, who is a doctor in Maryland. Introduce yourself, Richard.
Hello, so I am a practicing obstetrician gynecologist. I've been doing this for 15 years, and I work for the University of Maryland at the Capital Region Health Center. And I have a special interest in contraception access to poor women of color, big issue here in the DMV region, particularly with getting them good abortion access.
All right, and so I'm very excited to have Richard because we will do something that I think is a little unusual in the discussions of abortion towards the end of the show, which is we're going to actually ask a doctor. Imagine that. Like, imagine actually asking a doctor what they think about the right to choose. So to kick us off, let's start with what is happening today, what's happening in the court and why it matters. And so for our first question, I'd like to throw it to Anthony and ask, as our resident constitutional law professor, can you give us some insight on what's happening in the court today?
Yeah, so I think it's actually really, we'll take a step back and talk about what the law is and what the precedent that everyone's fighting over actually is. Because I think there's a lot of confusion about, what the state of the law is, but also, what's really at stake in terms of the legal analysis. So, of course, everyone talks about Roe versus Wade as being, right, the foundational principle that there's a fundamental right to abortion and to reproductive health. And, for a large part, right, that's true. But the most important case in terms of actually how the law works, right, in terms of how courts apply tests and analyze whether or not a particular law unconstitutionally prohibits or impedes a woman's right to choose, that decision is called Casey, right? Casey versus Planned Parenthood, happened in the early 90s. Roe versus Wade had set up in 1973 what we call the trimester system, or the trimester framework, where basically the Supreme Court tried to say essentially that in every trimester, the state's interest in regulating abortion increased, and therefore the states could impose more restrictions on abortion. In 1992, the Supreme Court ditched that framework in large part, but what they did was reaffirm the central holding of Roe. So what really is at stake in many respects is Casey in many of these cases, although I'm going to put a pin on that for a second, because I think what's at issue today is actually Roe. So it's kind of, which is probably kind of confusing to some folks. So I want to kind of peel the onion away a little bit more. So what Casey versus Planned Parenthood essentially said was that there's these basic kind of rules, right? That the first thing is that pre-viability, right? So in other words, before a child can live on their own outside the womb, a state can't forbid abortion, right? Post-viability, the state has a greater degree of interest in prohibiting and restricting abortion access, so long as it provides certain exceptions for example, the life of the mother and health and things of that nature. But the state still has the ability to impose certain burdens and regulations pre-viability. But there's a standard called the undue burden standard, which essentially says that if the regulation imposes an undue burden, in other words, if there's a substantial obstacle that's placed in the way of a woman seeking an abortion, that would not be constitutional. So there's this kind of burden, I don't want to call burdensome, that's not the good word, but it's a little bit trickier of a framework that the courts have to impose. So for example, the Supreme Court said in Casey that an informed consent requirement with some kind of 24-hour waiting period, that was not an undue burden on a woman's right to an abortion. Having a minor seek parental consent with some kind of judicial bypass, that was not a burden, undue burden, but requiring a woman who was married to seek her husband's or inform her husband prior to an abortion, that was an undue burden. So there's this kind of analysis that's done there. Now, I guess we'll probably talk about trap laws later, because I think that's a different, right? It's not a different, but a somewhat distinct issue. But what's at issue here is not really Casey, because Casey reaffirmed that one of the fundamental holdings of Roe, which was not only do women have a fundamental right to abortion access, but pre-viability, the state has a very limited interest in restricting abortion, right? That the state cannot wholesale ban abortions pre-viability. Mississippi has done in today, what the issue is at the Dobbs case is that Mississippi has said that at 15 weeks, with very few exceptions, but abortions are essentially banned in the state of Mississippi, which is a pre-viability ban, right? It's not some kind of regulatory scheme that imposes some kind of requirement on doctors or healthcare providers pre-viability. It is saying a certain subset of pre-viable pregnancies are unlawful. And so, so that's why I say, oftentimes Casey versus Planned Parenthood, right? That's the case that governs, and that's the precedent that really matters. While that's true 90% of the time, what's really at issue today, I think, is in fact Roe, right? And it is in fact the idea that the state does not have the capacity to pre-viability ban abortions. And that's really the fight that we're having at the Supreme Court today.
And Galina, I'd love for you to follow up, because, you're there for the protest today. And I'd love for you to talk to us a little bit about how an organization like NARAL is impacted by what's happening in each of these individual states and what's happening in the Supreme Court. We keep having, I feel like every term we've got an abortion case. And so how does that impact you as an organization that seeks to, provide women with access?
Sure. Well, I'm located in Virginia, where over the last few years, we've removed some of our worst restrictions on reproductive rights. So we've got rid of the 24-hour waiting period and a whole host of other restrictions. And unfortunately, during this election, it looks like the pendulum is going to swing the other way. We had a House election, and governors, lieutenant governors, and AG, all of the statewides went to anti-choice candidates, and on the House, we're still waiting for 2 seats, which if it goes our way, it'll be 50-50. If it doesn't, it will be 52 Republican members. and 52 anti-choice Republican members. So if the Supreme Court decides in June that Roe is overturned, then that emboldens the Republicans not just to reinstate the restrictions that we already got rid of, but really go a lot further than that. And in the meantime, it also is definitely emboldening the legislature to possibly reinstate some of those restrictions and seek to figure out additional restrictions that might not be covered by the current law or by the current case, and try to find novel ways to restrict because they see an opportunity. And regardless of the decision, because the court has agreed to hear it, it signals that there's a possibility to overturn. But also, Virginia is currently located to the south of us and to the west of us. If Roe is overturned, a lot of those states will entirely lose abortion access. And that means all of those people are going to try to seek abortion elsewhere, and a lot of them will come to Virginia if abortion remains legal and remains somewhat accessible in Virginia. So we're not just fighting for our own state, in our own state, but we're also fighting for all of those other folks who have to seek abortion and might have to travel north or east to us to get the healthcare that they need.
Right now, Anthony, I have a question. So, I've had folks texting me, questions all morning as the arguments happen, lay folks. And, one question I got was, if Casey gets overturned with the viability test, why couldn't we just go back to Roe with the trimester test? Like, why do both cases go if one falls?
Well, I mean, essentially, well, I think it's because of Dobbs, right? So if Dobbs comes out, I think the only way Mississippi can win is if the fundamental right underpinning of Roe, which upheld Casey, right, is gutted, because it doesn't fit with Casey, right? So because it's a pre-viability ban, I don't think the Casey framework is really an issue. It is the core fundamental holding of Roe that is at issue. And if that is undermined and gutted, then Casey falls along with it, right? You could see a scenario where Casey gets overturned or modified, but the fundamental underpinning and holding of Roe is upheld. And so I think that's really what's happening here, right? Is that I don't, unless you significantly modify Roe, which I don't, or Casey rather, which I don't think you're going to see. I think Roe is just going to go out the door. Now, in many ways, right, Casey is a much more permissive ruling for abortion restrictions than the Roe trimester framework was. So if the court is anti-Casey, then the court is certainly going to be anti-Roe as it was originally handed down. So, it's really, I think it's really, this case is really quite precarious for abortion rights, because it's almost, I guess the way I've described it to some of my students, it's like, you're playing Jenga and you're going for the piece at the very bottom that's upholding everything. And so if you knock that piece out, and that's what Dobbs would allow, the entire structure is going to fall. So I really think that's what we're seeing here. And that's why, in many respects, this is kind of I think in many respects, it might be the death knell of abortion rights as a constitutional right.
I have one question that's kind of not in our plan, but, if we're waiting until June for Dobbs to figure out Texas, isn't that essentially a ruling in and of itself to let it stand that long, right? If we let a Texas ban stand from September to June, regardless of what the outcome is of Dobbs, is that not signaling to everyone that suddenly we can combine civil procedure with our constitutional law, and we can at least get a rights restriction for almost a year if we simply combine civ pro tactics with con law?
I mean, how many women have already been denied right access to reproductive health care because of the Supreme Court's inaction? And every day that they wait, there's somebody else who loses the access or will have to be forced to leave the state of Texas in order to seek healthcare. I think that the scary part is, on the one hand, the justices recognize that the Texas system, which essentially delegates to private parties the enforcement of laws to restrict constitutional rights, that is a danger for their own interests, right? And they see that, you can see coming down the pipeline, right? Anti-gun laws that do that, or any other host, number of different things that really threaten conservative interests. So they're not going to let that stand long term, because that's the long game, that's also not good for them. At the same time, I think what's happening is the court is testing the resolve of the American people, because the more that Texas de facto has banned abortions in the state, and the more that they look around and say, oh, people will just tolerate it and accept it, the more likely it is that Dobbs is going to come out in a way that overturns the entire apple cart, and Casey will be out the door, and so will be the fundamental underpinning, right? That was the key holding in Roe. So every day, I think that the Texas abortion law is allowed to stand, even just as a civil procedure matter or a Fed courts matter, is another day that marks the more likely death knell of Roe via the Dobbs decision that the court is listening or having arguments over today.
Galina, how has NARAL dealt with the existence of the Texas law and sort of your fundraising and your planning? Are y'all kind of anticipating a world where you may need to shuttle women across the country or even out of the country just to give them the services that you seek to provide?
I mean, there is a broad national coalition of folks, including providers, national organizations, statewide organizations, abortion funds, advocates, activists, who are and have been working that specific problem. And yes, that if, as SB 8 still stands in Texas, there are already women traveling to Maryland to get abortions, to other states to get abortions, right? Especially because right now the states that are bordering Texas where abortion is available, those clinics have long waiting lists because they have reached their capacity. So absolutely, that is a consideration. NARAL Purchase Virginia, we don't provide direct services. So our fundraising is particular to Virginia politics, policy, grassroots work, advocacy work. But we are helping abortion funds fundraise, right? We uplift our abortion funds, and those abortion funds are providing services, and our independent providers in Virginia are providing services, including services to folks who are coming from outside the state. And it's not just people from Texas, it's people from Tennessee, it's people from West Virginia, because in those states, abortion is also restricted and they have fewer clinics, and it's easier to travel across the border to Virginia than try to obtain abortion in those home states.
Galina raises a very important point, which is that supporting organizations like NARAL and supporting organizations that are engaged in this state law advocacy is very, very important. And so I just want to remind y'all that NARAL is a nonprofit and could use your donations. And so you can donate at https://secure.everyaction.com. And then it'll, tell you from there how to donate to NARAL Pro-Choice of Virginia. And so we greatly appreciate your donations to help us keep this fight going and to make it a world where, should Roe fall, at least we can engage in a state-by-state fight to make us have abortion access in as many states as possible. Now, Anthony and I have both written on some of these issues, and we even both participated in a virtual roundtable at my home institution, Washington and Lee, that focuses on my tweet from a couple of years ago about fetal personhood and abortion bans. So my article, which is entitled, "If a Fetus is a Person, It Should Get Child Support, Due Process, and Citizenship," and Anthony's article entitled "Under 10 Eyes" are both available at the law school's Law Review's website, http://lawreview.wlu.wlu.edu in the roundtables category. So you can go read all of our articles on these issues and see that we just don't do this for fun. Like, we actually are all experts on these issues while you're donating to NARAL and other organizations. Now, for our next topic, what I would like to do is get technical. those of us who work in the pro-choice movement throw around a lot of words like trap laws and LARCs and, all these words that people really don't understand what we're talking about. And so I just want to talk about what some of these legal terms mean. And for this one, I'd like to start with Galina, who is a policy director and obviously has to communicate some of these scientific terms to legislators and other lay people. And I'd love for you to kick us off by telling us, like, legally, or even just in the context of case law, what is viability? Like, what do we mean when we throw around the word viability?
So viability isn't a fixed point in time. People tend to think of it as a fixed point in time, but every pregnancy is different. And in every pregnancy, the point at which a fetus, if it was delivered, could survive is different. Currently, the accepted standards are around 24 weeks, but that varies from pregnancy to pregnancy. So when the Supreme Court talks about viability, it pinned its standard on something that is ill-defined and is not a concrete thing and is a little bit arbitrary because it varies from pregnancy to pregnancy. So I would say that was a flawed standard in and of itself, but having the viability standard does mean that before viability, under the current law, states cannot restrict abortion beyond what has been called undue burden. And after that, they have a lot more of an ability to restrict. But that kind of varies from state to state. So in Virginia, we have a trimester network and a trimester framework. And in other states, there's a viability framework where they do point at a specific time during pregnancy. But that is not a medical distinction. That's a distinction made in the law that's not necessarily grounded in medical science.
And, I always find it interesting. Our resident doctor actually had to go deliver a baby, as OB-GYNs do. And so hopefully he'll be able to join us for the Q&A session at the end. But, whenever, just in law school and in studying these cases, I always found it fascinating that the Supreme Court picked a term and picked a point in time that a doctor would not use. The American College of Obstetrics and Gynecology, I don't even know if they use the word viability. They use a lot of other factors in deciding, when a woman is allowed to continue to have, still have access to an abortion. And so it's also fascinating to me that legislators that are full of, people who could not identify female anatomy on a chart or on a diagram just kind of pick arbitrary, points in time of deciding when women can and should have access, which kind of transitions me to the next, kind of thing I love a definition of, and I'll turn to Anthony on this one. We've seen trap laws, and we've seen trap laws stand, varying degrees of trap laws. So I'd love for, Anthony, for you to just tell us what a trap law is, and we can kind of chat about what types of things have been allowed and been found to not be an undue burden.
Yeah, so trap laws they're targeted restrictions on abortion providers. So it is an acronym. And they're essentially, these regulations on abortion providers, which, on their face could be seen as neutral, but which in fact are not, right? They are very costly, very highly regulatory, often completely medically unnecessary, completely unremoved from science or evidence-based, legislating, and these they're right. So there's I would call them like these kinds of requirements, and they're imposed on abortion providers in the hopes that they will be so burdensome that they will make abortion access either completely unavailable in a state or almost impossible to obtain in a state because, nearly, we'll say almost no abortion providers will be able to meet those regulatory standards, or very few will be able to. And, again, on their face, you could look at them and maybe an average person would say, oh, that seems reasonable. But when you peel, again, the layers of the onions back, you realize that there's something much more sinister afoot. And so, for example, I think the two biggest ones that we saw happen a lot, I would say pre-2016, so maybe 2010 to 2016, were these requirements that abortion providers basically were held up to the same code requirements as ambulatory surgical centers, right? So if you were having a minor, well, maybe not minor, but a more substantial but surgical procedure, but didn't need to be admitted to the hospital, right? That there were certain standards that were laid out for providers of those kinds of services. But that's not necessary for abortion providers. And so, states were trying to create these requirements that said, well, abortion providers need to be upheld to the same standard as ambulatory surgical centers. And we needed to do this for, women's health. We're out of the interest of making sure that abortions are safe, right? But that's also completely untrue, right? It's not necessary to have those kinds of standards for abortions to be safe, because abortions were overwhelmingly safe well before those standards were put in place. Similarly, you would have requirements that doctors doctors performing abortions would have to have admitting privileges at a nearby hospital, which is also, again, not medically necessary, and is unrelated to the safety of abortion services. And so, again, right, the argument would be made, this is a insurance policy to prevent, some kind of medical catastrophe, or to protect women from bad situations. But it's, again, not right. There's nothing in the evidence. There's no evidence to suggest that was the case at all. So in 2016, the Supreme Court held in Women's Health, Whole Women's Health versus Hellerstedt, that these kinds of trap laws are going to be subjected to a kind of heightened judicial review, right? A heightened scrutiny. And the courts really need to look at the underlying rationales for these policies, and not just kind of take the state's justifications at face value. Now, this is key, because what Whole Women's Health basically said was that we're not going to look at undue burdens in these trap laws with a kind of rational basis review. Rational basis review being this idea that if the state has a plausible justification for something, and it's not a discriminatory regulation, it applies to everybody. I'm oversimplifying this a bit, but basically that as long as there's a decent justification on paper, the court is not going to second guess that legislative judgment. That's not what the court said we need to do in an undue burden case, right? Going back to Casey, when these trap laws are put into place. So essentially, what the government or the court said that governments have to do is show what the stated government interest is, and explain precisely why that interest is necessary, and kind of explain the kind of cost-benefit analysis. So in other words, the state has to show that there's not only a state interest in these laws, but that this advances directly that state interest, and that the costs of the state's interest don't vastly outweigh the burdens that are imposed on women, and that courts need to demand actual evidence for the justification supporting these laws, right? So we're not just going to take the state's word for it, that the state has to produce evidence that these things are necessary. And on top of that, that we shouldn't also think about these things in piecemeal, right? So you might look at, for example, the ambulatory surgical care center requirements and say, well, that might be rational, that might not be not, and kind of look at it, right, as a singular thing, or look at the admitting privileges requirement and looking at that as a singular thing. But we also should look at the regulatory scheme as a whole, right, and the cumulative effects of the abortion regulatory scheme that is put in place by a state. And so that, right, so that kind of, oftentimes a constitutional law, right, we think about laws as they come to us, right? So we look at one law and say, okay, what's the justification for this particular law? How does this weigh out given the interest of the state and whatever it does, to other folks, or discrimination, like. But here we're really doing a much more comprehensive approach to understanding how the entire regulatory scheme might impose a burden on a woman's access to abortion and reproductive health care. Right? That's not rational basis. That's a, it's not strict scrutiny either, but it's certainly a fairly robust inquiry as to what is the state doing, what is the state trying to achieve, does it actually achieve that interest, and is there actually some other kind of thing, is there something else happening here, right? Is this all pretextual in order to just eradicate abortion providers and limit the access to reproductive health care for women within a particular state? So, that's a very important case. Now, again, that was 2016. Right. So we're only talking almost 5 years ago that came down, and the Supreme Court reaffirmed it, a couple of terms later in a case called June Medical. So it is remarkable that we are here in 2021 relitigating things that were not just firmly established in the law, but reinforced right in the last 5 years, not just once, but twice. And to kind of go back to our roundtable, right, to reference that, what I wrote in that piece, and I think what we've engaged in dialogue since, is that there has been no fundamental change in the science, in healthcare practice, or anything that justifies overturning Roe, Casey, and whole women's health. There's nothing. What we have here is a political dynamic, a political coalition, which has had, secured a stranglehold on the Supreme Court because you had a president who was elected by a minority of Americans, right? Not even a plurality, but in fact, a minority of Americans, who then nominated 3 justices who were then ratified or confirmed by a Senate with a majority vote that was representative for the first time ever of a minority of Americans. And now they have the ability to overturn a precedent which is supported by a majority of Americans. And this is their opportunity, I think, for them, or so they think, to snuff out abortion rights once and for all. And if it's not now, it'll never come to pass. And so I think that we need to stop talking about this as being a matter of precedent, or whether stare decisis matters, or whether this is really about science or principles, or whether it's about the rule of law. It is about none of that. It is fundamentally about one thing and one thing only, which is power.
Yeah, and I find it fascinating. I love that Justice Sotomayor today chose to open with that foundational question of how can people possibly have trust in the courts if it is clear that the only reason you're bringing this case is because the composition of the court changed, right? There is no other reason to bring this case other than the composition of the court changed. Now, one thing I'd love to talk to you a little bit about, Galina, is, Anthony mentioned how, we've got Hellerstedt in 2016, but up until 2016, we've had the Hyde Amendment since the beginning of time, which restricts federal funds for abortions. We've had these incremental kind of incursions on the right to choose since then. And as we wait for Supreme Court cases to happen, states either, clinics close, or, private doctors feel they can't perform abortions anymore. And so I would love to talk with you about the disparate impact of this cycle of legislation, especially in combination with the Hyde Amendment.
Certainly. So one thing to remember about Hyde is, one, it's fundamentally racist, and two, it's fundamentally classist. If we look at what Representative Hyde actually said about his Hyde Amendment, I would certainly like to prevent, if I could, legally anybody having an abortion, a rich woman, a middle-class woman, or a poor woman. Unfortunately, the only vehicle available is the Medicaid bill. So he specifically targeted poor women because he could not, or did not feel like he could, target other women. And when you take Hyde, which prevents public funding from being used towards abortion care, and you take this plethora of restrictions across the states, these have a disparate impact, negative impact on women of color, on poor women, on women who are in rural districts. So if you have a job and your job that will not let you take multiple days off work to go get an abortion, the 24-hour waiting period is a huge burden, or the 72-hour waiting period that exists in other states, right? If you cannot access abortion through Medicaid, then you have to pay for it out of pocket, and it can become entirely inaccessible because it is not a cheap procedure. If you are living in a rural area, you may not have a provider within many, many miles because of the restrictions have made it so difficult for independent providers to provide abortions in those more rural areas. And so all this latticework of restrictions in combination with Hyde really has affected, disproportionately affected, women of color, women who are low income, people who are pregnant, people who are low income, and people in rural areas. And it's important to remember that Black women are 4 times more likely to seek an abortion than their white counterparts. That means the impact is even more disparate on folks who need that care the most. So when we think about, abortion rights, and we think about Roe, and we think about Casey, those were promises that for many people have gone unfulfilled, right? That's the right for middle-class white women. And other folks have had difficulty accessing that right for decades. So when we think about state advocacy, especially in states that, are more blue, have more pro-choice legislators, the push has to be not just to codify Roe or codify abortion rights. The push has to be to overturn the state Hyde restrictions that exist, to provide funding for abortion care, and to expand access. Because right now, even in some of those states, even in states like Virginia, where we do have restrictions on, state funding for abortion care, many women still find accessing the care very difficult. Many pregnant people still find accessing the care very difficult. So I would say, think broader than Roe when you're advocating for abortion rights.
And one fact I find fascinating. I was on the board of Planned Parenthood Gulf Coast in Houston. And Houston is obviously a large metropolitan area, and so that abortion clinic is large. But there, even pre all of the recent developments, maybe in the entire state of Texas, there were 12 abortion clinics. And Texas is the size of France, right? Like 12 abortion clinics in that entire state. And the whole women's health, the Dobbs v. Jackson Women's Health today. It is worth noting that Jackson Women's Health is the only abortion clinic in that entire state. There may be 2 in Louisiana. So even in the context of now, when things are supposed to be good, there are several states with 1 clinic, no clinic, et cetera. And so you already have women who have an undue burden because of the incremental incursions on the right to choose since Roe and since Casey. And when you think about the economic factors of who has time to take off work and go get a transvaginal ultrasound on one day, wait 72 hours and go back, and then have a procedure and possibly need to take a 3rd day off of work, that is definitely a class issue and a race issue. And so it is, it feels intentional, especially when you target Medicaid, add these waiting periods, and kind of disregard the fact that, the earlier you could have this procedure, the easier it is. And you are intentionally making it longer, which then makes it more difficult to have the procedure and to have the time to take off. We've mentioned the Hyde, and we've kind of mentioned the Hyde Amendment back and forth without defining it and like what it is. And so since we're in the define these terms segment, either of you would like to just explain, what the Hyde Amendment is.
Sure. So the Hyde Amendment under federal law restricts federal money from going towards abortion care, and it affects all kinds of parts of the budget, but specifically Medicaid, the part that kind of is especially concerning is Medicaid cannot pay for abortion care. Federal Medicaid cannot. Now, in some states, they do allow state funds go to Medicaid patients who get abortion care. Virginia, for example, does not, except in cases of rape, incest, life of the mother, or in cases of very severe fetal abnormalities. So every other person who needs an abortion has to pay out of pocket or they have to have insurance that covers abortion care. Well, in addition to Hyde, in the in Obamacare, there's the restriction that on the national exchange, you can, and on some state exchanges as well, you can't have plans that cover abortion within the same plan. And there's some kind of exceptions and ways around that. But in Virginia, until last year, even on the state exchange that is being created, you would not have been able to obtain coverage for abortion through your insurance. So that really restricts the ability of folks to get abortion who are lower income. Thankfully, we do have a lot of abortion funds, but the demand is bigger than the amount of money and resources those funds have. So if you really care about abortion, it is important to support not just groups like mine who do policy work and advocacy work and Planned Parenthood, but also those abortion funds that are the safety net for folks who cannot get abortion coverage through Medicaid or through their insurance and need the money to be able to obtain the procedure. Because the longer you wait, as Khaleesi said, the greater some of the risks are, the harder it is to go through the procedure. And if you're trying to get enough money together to have an abortion, you might make it past the viability standard, or make it past the point where you can go to a abortion provider and have the procedure, and have to go to a hospital to get the procedure, which increases the cost dramatically.
Now, what I find interesting about the Hyde Amendment impact on private insurance via the exchange is one of my true passions, which is corporate law and corporate governance and corporate personhood, because it is fascinating to me that your private insurer can be bound by what feels like a religious exemption, per Justice Sotomayor this morning, from allowing your private insurance to cover abortion care simply because it is going through the federal exchange. And I feel like that's a great transition for Anthony, who also loves Hobby Lobby and all of those personhood cases, to kind of tell us about how the Hobby Lobby decision and those corporate personhood decisions are impacting this abortion debate as well.
Yeah, so I actually think there's a couple of things going on here, and I think Hobby Lobby is one of them. And I think there's another issue, which I'll rope in here too, where the Supreme Court is doing a very ugly pincher movement. And by that, I mean, while they are restricting abortion access, probably in Dobbs on the one hand, whatever safety valves might be there to alleviate whatever bad consequences are yielded from overturning Roe or Casey, they're kind of they're preventing those safety valves from being released and exercised. So by that I mean, for example, in Hobby Lobby, the Supreme Court held that the Religious Freedom Restoration Act gave employers, so corporate employers, who had a religious objection to providing contraceptives for free through their healthcare plans, had an out as a matter of federal law, and that the federal government would have to find another workaround in order to ensure that contraception access was provided to employees of those employers with religious objections. So first of all, I think that's kind of crazy that there's this idea that a corporate interest has a religious belief that could be substantially burdened, and that's a whole mess that we could have an entire podcast on. All right, but the idea that that somehow that the federal government is restrained from ensuring, or it's at least burdened from ensuring that employees have access to contraception, that actually makes unwanted pregnancies more likely, which raises the likelihood of women needing abortions. So it doesn't, in many respects, from, if you're kind of looking at it from a policy perspective, it's a really tough thing to swallow when you look at it and you say, well, you want to restrict abortion access, but you also want to make it harder to get contraception coverage, which would limit the number of abortions you would see. So that kind of preventative healthcare, right? And that's actually just true, just more generally, right? With folks refusing or resisting Medicaid expansion, right? If your ultimate goal, right, is to limit the number of abortions and reduce it to a very small number, then you should give people access to healthcare, right? And give them the choices and the ability to exercise autonomy before they get to that point. And then not judge them if if you do get to the point that you need to have that kind of health, abortion access. But on the other hand, and I think this is also equally damaging, right? So this is the other pincher movement, is that you're hearing arguments of, well, this should just be returned to the states, right? That it's this Alex Bickle nonsense of the counter-majoritarian difficulty. Well, you've removed the issue of abortion from public debate, from public scrutiny, from the legislative process on the states, et cetera, et cetera, et cetera. Well, let's take that argument as, on its face as, okay, not a problem. Like, let's just return it to the states. Mm-hmm. Well, the Supreme Court has refused to do anything about, for example, gerrymandering, right? And so you have states like North Carolina, like Georgia, like Wisconsin, like Pennsylvania, right? Where, Ohio, for that matter, where the electorate does not reflect, right, the representation that's provided in those state houses, right? What incentive is there for North Carolina state legislators, for example, to be fairly moderate, right? Let's say Roe is overturned. North Carolina is a 50-50 state. Mm-hmm. In a 50-50 state, you might see, right, a legal regime that reflects something like Casey, right? Like something that actually, excuse me, something like the law as it exists today. But you're not going to see that because you have 60% of the legislators who are in safe districts, who are Republicans, and their interest is to crack down on abortion, notwithstanding what the state as a whole wants, right? So, you've got these, again, it's like these pincher movements where all these safety valves that would otherwise be there to perhaps mitigate the damage that the court may well do in Dobbs, right? Those, they're undermining it at every turn. And I think it's really both damaging for women's autonomy, yes, absolutely, but it's also just bad for democracy, right? Where we don't have, where folks, their fundamental rights are on the line. And, when you're putting them on the line, you're not even allowing them to have a fair fight in the state houses and, with the folks that represent them. And I think that's very dangerous on multiple levels.
Well, and what always bothers me about why don't we return it to the states is, like, did we not have a whole civil rights movement where we learned that the states should not be allowed to do some things, right? Like, the states are incompetent when it comes to preserving equality and giving people rights. The last thing I want personally is for the state of Virginia, Texas, or anyone to be deciding my personhood or my autonomy or my privacy rights, because history tells me that it will not go well for me, right? And so I always find it interesting that, at its core, Roe v. Wade is a 14th Amendment right to privacy decision. If we think about when the 14th Amendment is passed, right, it's a Reconstruction Amendment. And so the response of, well, let the states have it, it's like, well, isn't that the whole point of the 14th Amendment? That the states are not competent at giving people personhood rights. The states are not competent at equality. So how dare you say, like, let's return this part of it, women's autonomy, back to the states. Galina made a very important point in the chat that I want to get out, is that, the very same people who want to restrict abortions are also against childcare, paid family leave. If you look at the current debates in Congress, and you look at all the things that are happening in the press, when we talk about, oh my God, millennials don't want to have babies. Well, it's like, how can we afford to? Who can afford to have a baby when it costs $20,000 a year to do daycare? And when we all have student loans, and when salaries haven't gone up, and when my healthcare doesn't pay for even just birth control, so I have to pay for that out of pocket. The system really isn't stacked up for the outcome that people desire. Right. One other point that I want to make is there are these things called trigger laws, which we did not define. And what trigger laws are is that as soon as Roe v. Wade, if Roe v. Wade is overturned by Dobbs, the very same day, there are at least 22 states where abortion is banned completely, because they either have old laws on the books that will just be reinstated, or they've got laws that will immediately ban abortion when Roe is overturned. So you will go from one day having, a majority, but not a good majority of women having the right to choose, to virtually no one. Because when you look at the cluster of where the 22 states are, most women won't have access. All right, so we've only got 5 minutes left. And obviously there was a Supreme Court case today. And so what I'd like to do for the last 5 minutes is let my guests tell me their predictions. What are your predictions for Dobbs v. Jackson? And I'll let Galina go first on this one. What are your predictions?
I think, judging from the questions from the conservative members of the court, they're definitely leaning towards overturning. And we know that, Justice Roberts is very concerned with the court's image and stare decisis, and he will likely side with liberal justices, but he's no longer the swing vote. We have 6 very conservative justices, and many of them have stated previously that they are anti-choice, that they think Roe was a bad decision, that they think Casey was a bad decision and based on bad principles. So I don't see us coming out in June and celebrating a positive result. And even if they somehow finagle a decision that damages Roe but does not entirely overturn it, I wouldn't be surprised that would open the floodgates for additional restrictions across the states.
Anthony?
Yeah, I think that the more I've listened to oral arguments, before we hopped on the call, and just the kind of gut instinct I've got, I think that Casey is basically going to be gutted. Roe is going to be pared back to essentially nothing, if anything. And if there's anything that's going to save, either the core holding of Roe or some form of Casey, or a combination between that, it'll be because Justice Gorsuch and Chief Justice Roberts come up with some, I think they're the ones to watch. I think they're the ones, if anybody, will find some very narrow way to keep up, hold up Roe, because Justice Barrett thinks there's no reliance interest and that she's just writing on a blank page. I think Kavanaugh is pretty clear that he's anti-Roe. There's no question about where Justices Alito and Thomas are. And so I think it really will come down to the Chief Justice and how much he thinks the court can withstand a public backlash, and how far Justice Gorsuch is willing to go along with the chief on that one.
Yeah, I have no faith, but I mean, I was negative for June. Like, I was like, we're not even going to win June Women's Health. Like, I just have been, convinced that we will, we essentially have bans on abortion in most states because, so many states have 0 clinics, so many states have 1 clinic. When you look at the impact of trap laws, that has all but eliminated abortion in some states. Oh, Richard, you're back, as we have like 2 minutes. So we will have to have Richard back another time. But, we look at the impact of trap laws and other laws. And so I basically have 0 faith that the right to choose will stand. And I'm not even as optimistic as Anthony. I think that, we'll get a minority, that Roberts joins the minority. And I don't even think Gorsuch is going to work to craft something in the middle. I could see him signing on an opinion written by Alito and us having a 5-4 decision that essentially guts everything. And I felt from the oral argument that they were trying to craft a kind of ad hoc, like, we're not really undoing it. It's just that Casey was wrong. And I just felt like they were into some creative constitutional law, manipulation that the court is often wont to do. All right, so we've only got a couple minutes left. And so I would love to thank my inaugural guests for joining me on this first episode of Getting Common. It is available on the Voice America website. And I forgot to mention the call-in number, but this is a call-in show if anyone desires. I just keep forgetting to say that. We will upload this full episode onto YouTube at some point. It is also available as a podcast on iTunes. And you can join us this time next week when our topic will be Free the Hair. And our guest next week will be Wendy Green, Professor Marissa Jackson-So, and Rashida Thomas, and we will talk about hair care discrimination. You are free to send me emails through through the show webpage, and you can reach out to me on social media. I'm at Carla C on all platforms, and on the YouTube channel and the other posts, I will put in all the links and ways to reach our guests. So thank y'all so much for joining us today. Thank you to Anthony, Galina, and Richard. Greatly appreciate you being here. And maybe the world will not be as pessimistic as we feel. Maybe like there can be some positivity there. I don't know. All right. Thank y'all.